This lesson will focus on legal entities and employer-employee relationships. Within this lesson, we will first distinguish the various types of employees and then discuss relevant federal employment laws that pertain to our industry, talk about the burden of proof broadly from the perspective of the plaintiff and the defendant, and then discuss possible defenses to an employment discrimination lawsuit, as well as remedies if a defendant was found liable for employment discrimination. Let's first start by distinguishing all of the different types of employees that you may come in contact with or work with while in the industry. On this slide, you'll see a comparative table that illustrates regular employees and independent contractors. So a regular employee is one who is hired, paid a set wage or salary. So typically they're paid by the hour, week, or month. They are often trained by the employer. They work on an ongoing basis, and they must perform the work as directed by the employer. So there is an element of control that the employer exerts over the employee. However, the employers also have a greater amount of financial responsibilities to the employee, such as paying their wages, providing unemployment insurance, workers' compensation, benefits, and other negotiated services, as well as providing all supplies and equipment necessary for the employee to do their work. Now, in comparison, when considering an independent contractor, they are one who is generally engaged for a specific project. So an employer is hiring an independent contractor for a very definitive project. They're usually paying the independent contractor a set sum of money, typically at the end of the project. The independent contractor may do the job in their own way. They're often furnishing their own equipment. They're subject to minimal restrictions and control or direction from the employer, and they are responsible for completing the job in a satisfactory manner. So the employer has very little control over the training or the means by which an independent contractor accomplishes the tasks involved in the project. When comparing liability for a regular employee versus an independent contractor, there's this legal concept called vicarious liability that comes into play. Generally speaking, an employer is legally responsible for all work-related torts committed by an employee. So there is liability when you're engaged with regular employees. However, there's less liability when you are engaged with independent contractors. An employer is not liable for the torts of independent contractors. The only time an employer would become liable for any negligence or intentional tort of an independent contractor is if it is due to a hazardous work environment that the employer should have made safe from the beginning, we'll say, or the employer violates the status of the independent contractor. For example, if they exert too much control over the independent contractor, as soon as you start treating an independent contractor like a regular employee, you are then going to also assume liability for their actions and for their work. So for vicarious liability, typically managers are going to be considered liable for any torts that are committed in the workplace by an employee, but not an independent contractor. So there are some benefits there. Now, when determining whether an individual is an independent contractor, the courts will consider several factors. So for example, they will look at control. So who's in charge of this individual? They'll look at the work and the skill level of the independent contractor. Like, does this job or project require special certifications, licenses, skills that are unique and advanced, so unique and advanced that you need someone with those special skills, someone that you can't control their actions because it's difficult to control a project that you know very little about. It's the reason why you contracted out, right? So they're going to look at the nature of the work, and they'll also look at the period of employment. Is it an ongoing basis or for a specific period of time around a particular project? They'll also look at that compensation. So please note the differences in this table, and also be aware that as a sport manager, you must treat different types of employees based upon their classification because it has liability implications. Now, there are a couple of other different employee types that I wanted to discuss. On this slide, you'll see the difference between a leased employee and interns and volunteers, which we are all very familiar with. Now, with leased employees, it's kind of a combination of a regular employee and an independent contractor. When a professional employer organization, that's the PO acronym that you see in that graphic, or a leasing company, employs workers for another business, and then also manages all of the human resources involved with that employee, that process is known as employee leasing. So in leasing employees, the employee is an employee of the leasing firm. So they're a regular employee of the leasing firm. They're given a salary, they're given fringe benefits from the leasing firm, and all liability for that employee is attributed to the leasing firm. The leasing firm will also hire, fire, evaluate these employees. However, the leasing firm, one great benefit of using leased employees is that they take on the significant human resource services and responsibilities. They take care of all payroll administrations. They handle all compliance issues, and they can really safeguard you and your business from liability due to the torts of that leased employee. It also helps safeguard you from any possible repercussions of changes in regulatory laws. Because the leasing firm is really the ones that are responsible for the employees. So these leased employees are an independent contractor for you. So lots of benefits there in terms of bringing a special skill for a specific task to be accomplished and limiting your liability. However, they are a regular employee for the leasing firm, which has implications in regards to the firm's responsibility over the employee as well as their liability. Now, please note that interns and volunteers are not considered leased employees. They are of their own entity. Now, with interns and volunteers, we should really look into the Fair Labor Standards Act, which we'll talk about in a couple of slides, because the Fair Labor Standards Act will distinguish what constitutes an internship and does it need to be paid or not. Now, higher education, athletics, we often see interns in our industry. It's a really great tool to gain training and education in a career field that you are interested in entering. However, there's a lot of issues with should the intern be paid or unpaid, because they're providing a valuable skill, they're providing time. However, it's also associated with your education. And so employers and sport managers are bound by the Fair Labor Standards Act to uphold certain requirements for an internship to be unpaid. If they do not uphold those requirements, which we will review in a moment, then that intern must be paid minimum wage with overtime where appropriate. We will get more into that in an upcoming slide. When looking at the employee-employer relationship and employment laws broadly, there are a number of laws that pertain to employment, and more specifically, employment discrimination. So on this slide, you will see there's the Fair Labor Standards Act, Equal Pay Act, Title VII, Age Discrimination in Employment Act, Title IX, Rehabilitation Act, and Americans with Disabilities Act. We are going to focus on the first 5, as the Rehabilitation Act and Americans with Disabilities Act was covered in a previous lesson. I wanted you to note the asterisk because the majority of lawsuits that are involving employment discrimination will go through the Equal Employment Opportunities Commission. So this governmental agency will manage all claims pertaining to employment discrimination. However, you'll note that the one federal employment law, Title IX, does not directly go to the EEOC. Typically, when there is a Title IX complaint, it will first go to the Office of Civil Rights. However, if that Title IX complaint does involve employment discrimination, it is often deferred to the EEOC. So in general, when in doubt, just know that this is the government agency that will examine all employment discrimination complaints. So let's go through each one of these federal employment laws so you have a good understanding of what they are and how they impact our industry. We'll first start off with the Fair Labor Standards Act, which is helpful since we were just talking about interns, volunteers, different types of employees, and all of that good stuff. Now, the Fair Labor Standards Act requires that most employees in the United States be paid at least the federal minimum wage, which, as you can see on this slide, is right around $7.25 for all hours worked. And it requires that these employees receive overtime pay at not less than time and a half the regular rate of pay for all hours worked over 40 hours in a work week. Okay, so guaranteed minimal wage based on the federal rate. You get time and a half for work that is over 40 hours, and then it does also impact child labor protections. Now, when it comes to the Fair Labor Standards Act, there are exempt employees and there are not exempt employees. So basically, this act pertains to most employees in the United States, but it doesn't pertain to all. Exempt employees are exempt because their rate of pay or their type of work that they do are not eligible for overtime pay hours. To give you a bit more information, the Fair Labor Standards Act provides an exemption from both the minimum wage and overtime pay requirements for employees who are employed as an executive, administrative, or professional employee. And so what that means is this employee makes at least about $35,000 a year, roughly $684 per week. So they make a certain amount of money in their job. And also their work responsibilities are typically office-related, non-manual work, related to the general business operations of their employer. These employees' duties typically allow them to exercise discretion and independent judgment with respect to significant matters. And so these exempt employees are essentially not eligible for overtime pay. That's why a lot of salaried positions within our industry, you may work over 40 hours, but you may not get overtime pay for that. It's because you're considered exempt due to the nature of your work and the amount of your salary. And it's not based on your job title. It's really just based upon your pay and your job duties. So I wanted to clarify that this act, these requirements, it only applies to the non-exempt employees. If you're non-exempt, then you have to be paid time and a half for overtime. You have to be paid at least minimum wage. And what you'll see on this slide is actually pretty unfortunate. In terms of our minimum wage, right now it's at $7.25, and it has been low for a while now. At its peak was in 1968. So this act came about in 1938. The highest federal minimum wage based upon inflation was in 1968, which in US dollars today was $10.54, and now it's down to $7.25. But I wanted to point that out just so that you keep in mind the federal wage may be changing. I am so curious to see what happens in the future, because there is a really big push to increase the minimum wage to $15 an hour. It didn't really go anywhere with the Trump administration, so we'll see with the Biden administration if this proposal moves forward. But the hope is to increase it to $15 an hour by 2025 in order to address a lot of poverty issues in our country. So to be determined there, but it will impact you in our industry. And then also, when talking about interns and volunteers, once again, let's talk about that unpaid internship. If you are a sport manager and you have interns that are, supporting your business operations, for that internship to be unpaid, it needs to adhere to certain qualifications or criteria. So the internship, it needs to be similar to training that the intern would receive in an educational environment. So the internship needs to be educational. It needs to benefit the intern. That needs to be the biggest benefit, is to the intern. It cannot displace a regular employee. Basically, an intern cannot be fulfilling the job responsibilities of a full-time employee. That intern should be working under close supervision. The employer should be providing training to the intern. The employee and intern should have a mutual understanding that the intern is not entitled to wages for the time spent in the internship. Often these internships are associated with some type of educational credit or a class. And then lastly, there needs to also be an understanding that the intern is not entitled to a job at the conclusion of the internship. Now, whether there is a job that opens up that they may apply for is different, but I hope what you're seeing here is that an internship, if it is going to be unpaid, it must have a primary educational focus and mission. So that graphic on this slide of a person carrying coffee, guess what? That's not educational. That's not adding to their development and their training. So if you work with interns and they are unpaid, make sure that you are meeting all requirements under the Fair Labor Standards Act and making sure that it is educational and not displacing any employees. But if they are a paid intern, they must be paid minimum wage with overtime if over 40 hours. Let's go to our next federal law, which is the Equal Pay Act of 1963. I ordered these in chronological order so we can kind of see how the law has evolved over time. Now, the EPA, so the Equal Pay Act, is actually part of the Fair Labor Standards Act. It's part of its amendment. It is also enforced by the EEOC, and it prohibits sex-based wage discrimination between men and women in the same establishment, so under the same employer, who perform jobs that require substantially equal skill, effort, and responsibility under similar working conditions. That's essentially what the Equal Pay Act prohibits. So it is focused on employment discrimination, but it's pretty narrowly focused specifically on compensation, so on pay. And in the courts, when there is a alleged violation of the Equal Pay Act, the courts will try to examine two comparable positions. Like the plaintiff will need to bring forward a equal comparator position and establish that that equal comparator position is receiving higher pay in order to prove differential pay for equal work. So the burden of proof is first with the plaintiff, and the courts will look at equivalent skill in terms of experience, training, education, ability. They'll look at equivalent effort, which involves the amount or degree of physical and mental exertion required for the job. And then they'll also look at equivalent responsibility, which looks at accountability and the importance of the job. So they'll look at those two things. And once the plaintiff has made a claim for differential pay for equal work, then the burden of proof shifts to the defendant, and the defendant, which would be the employer in this case, must justify their pay decision based on factors other than sex. So they could bring up differential skill, effort, and responsibility if they wanted to try and prove that it was actually differential pay for differential work. However, unfortunately, in our country, we have seen unequal pay for women historically. Honestly, it's why why we saw it enforced or came to being in 1963 and continues to be enforced. I think this graphic does a really nice job of illuminating the problem. So in the United States, women earn 82% of the full-time weekly paycheck of a man. However, as you can see, women of color are far more greatly burdened, where women who are white or Caucasian earn 82%, Black women earn 68% compared to men, Latina women earn 62% in comparison to men, Asian women fare a little bit better at 78%, but still, across the board, women are receiving a much smaller paycheck than, or considerably smaller paycheck than men. Even though to date, women make up half of the US college educated workforce. However, their full-time jobs are just not equivalent in salary, unfortunately. So this gap has persisted despite several efforts and initiative to try and close this gap. And a particular lawsuit that has arisen in our industry and just brought a lot of attention to the media is the 2016 complaint that was filed by 5 top players to play for the US women's national team. It was a class action lawsuit against the US Soccer Federation that was filed, or that complaint was filed through the EEOC. And as you can see on this slide, the pay gap is pretty apparent, and that was easy to prove. So the differential pay was demonstrated by the plaintiffs, so the soccer players in this case. However, there were some interesting arguments from the US Soccer Federation. So the US Soccer Federation indicated that the women are paid differently from the men because they specifically asked for and negotiated a completely different contract than the men's national team, despite being offered and rejecting a similar pay to play agreement during past negotiations. So if you look at the collective bargaining agreement of the men's team versus the women's team, their pay structure is inherently different. And so the US Soccer Federation is claiming that the differential pay is actually based upon the pay structure, which the women's team, through their union or their players association, had the right to negotiate and give input to and mutually agreed upon those terms. So the judge in this particular case found that women opted for pay that weighed fixed income more than performance bonuses, which is how we're seeing this pay gap. It's really based on the pay structure that they agreed to in their collective bargaining agreement. And so this case was thrown out on the compensation claims. However, the judge did find some merit in terms of other benefits that were differential, such as travel costs. But a really interesting lawsuit that highlights the gender pay gap we see in our industry, but also some key points about the Equal Pay Act. You need to be able to prove equivalent work, and also any collective bargaining that your association or union does on your behalf is going to have implications in regards to what the courts will deem you agreed to, essentially. Moving on to our next federal law to review is Title VII of the Civil Rights Act of 1964. So the Civil Rights Act of 1964 is a very comprehensive federal law that prohibits discrimination in a lot of different settings. Title VII specifically addresses employment discrimination. Now, while the Equal Pay Act is limited to equal pay for equal work, so it really focuses on equal pay within the employment context, Title VII offers a victim significantly broader protection. So it expands a lot more past just compensation. Under Title VII, it is unlawful for an employer to discriminate against an individual with regards to compensation, so similar to the Equal Pay Act, as well as terms, conditions, privileges of employment. They are not allowed to limit, segregate, or classify employees or applicants for employment in any way that would deprive them of employment opportunities, that would adversely affect their employee status, that would take away from any employment benefits. So any type of adverse employment practice would be considered discrimination if you are treating this individual based upon their race, color, religion, sex, or national origin. So it prohibits employment discrimination on the basis of those protected classifications. So you cannot treat that group of people or that individual differently because of their race, color, religion, sex, or national origin when it comes to employment practices. Title VII applies to employers with 15 or more employees working at least 20 calendar weeks whose organizations affect interstate commerce. So the majority of employers are subject to Title VII. They can be individuals, they could be partnerships, joint ventures, corporations, unincorporated associations. You get the gist. So the majority of employers, once again, are subject to Title VII. And just to look at the classifications one more time, any employment decision, practice, or policy that segregates individuals or treats them differently on the basis of their protected classification violates Title VII. So that includes race, which color often coincides with racial discrimination. So color focuses on the your skin pigmentation or physical characteristics. And then there's national origin. This focuses on one's ancestry. Now, a little caveat is that Title VII does not prohibit employment discrimination solely on the basis of citizenship. An employer may follow a policy of employing only US citizens, but may not give unequal treatment to different non-citizens based on their country of origin. So that's just a caveat to note. In terms of sex discrimination, which we'll go into more in the next slide, this has seen some really great expansions as of late. So on the basis of sex has been amended to expand protection to discrimination based on pregnancy, childbirth, or other medical conditions. And we have most recently seen the term sex to include the LGBTQ community as well as transgender individuals. Historically, it was limited to an interpretation of biological sex, which just focused on men and women and was not inclusive of other gender identities, but we are continuing to see this expand. And then religion as well is covered under Title VII. So really any recognized faith would be protected under Title VII. And as you can see from the graphic on this slide, I thought this was really illuminating in terms of who experiences workplace discrimination the most. And when we're looking at different groups of people, now disability is the highest in terms of workplace discrimination. However, please note that disability is not a protected classification under Title VII. If you were discriminated against based on your disability, you would want to claim the Americans with Disabilities Act Title I. However, The next the next classification that is most greatly burdened by employment discrimination is based on your race. So racial discrimination is very prevalent in our industry, unfortunately, and then sex, and then age, national origin, color, then religion. So it just gives you some perspective about where we're seeing employment discrimination the most. Another point to note is that age is not covered under Title VII. So there's the Age Discrimination in Employment Act that you would cite if you were discriminated against based upon age. And as mentioned, huge Supreme Court case decision, because there has just been a lot of back and forth in Title VII as well as Title IX about how do you define sex? How do you interpret sex? And it's really changed based upon the presidential administration. And so we've seen changes in interpretation, which really affects the rights and protections of private citizens. And so in this lawsuit, which is huge for establishing precedent, you'll find this holding that an employer who fires an individual merely for being gay or transgender violates Title VII. Essentially, what we're seeing now is that the LGBTQ community is protected under Title VII, where they historically did not receive that level of protection. So wonderful expanding provisions through these federal laws. The next federal law that we will talk about is the Age Discrimination in Employment Act. As I had mentioned, age is not covered under Title VII, so it is important that we know if there was age discrimination, well, how would you gain legal protection? With people living longer, healthier lives in our country, our workforce is steadily growing older. So this demographic shift has often come into direct conflict with the economic reality of reductions in the labor force, as well as other cost-cutting measures. So the ADEA came about in 1967, and it protects employees and job applicants who are 40 years of age or older from employment discrimination based on age. You'll see on this slide the various purposes of this particular law, which is to promote employment of older persons based on their ability and not based on their age, and to prohibit age discrimination within employment contexts, as well as to help employers and employees mediate potential problems that arise from just the general impact of age and how to navigate providing reasonable accommodations for these employees. Those that are subject to ADA are any employers with 20 or more employees working at least 20 weeks, so similar to Title VII. However, there's some limitations to the scope of the ADEA that I wanted to point out. Certain employees that are vital to public safety and welfare, such as police officers, actually cannot seek protection under the ADEA because of their job responsibilities, being critical to the welfare and safety of our society. And age has some implications in regards to how well you can perform that job. Also, employees who are under the age of 40 cannot seek relief under the ADEA, even if they are subject to discrimination in the workforce based on age. So you might experience age discrimination for your youth, but unfortunately you are not protected under this particular law. So just wanted to make that clear. And then this law also, if you experience age discrimination, you would file that complaint with the EEOC. And what we can see on this slide is, once again, how prevalent discrimination is for this protected classification. So in this particular research study, 64% of workers said that they have either seen or experienced age discrimination, over half, which is crazy. And 58% believe that age discrimination begins in someone's 50s. And yet 1 in 5 workers in the US is over the age of 55. And so many individuals in our industry experience age discrimination and adverse employment actions unfortunately, based on their age, but are still so comparable or competent. That is the word I'm going for, and vital to our industry. And this law provides a lot of great protections for them. The last federal law that I wanted to review was Title IX. Now, Title IX has a lot of different protections. We are going to focus on the employment context. Title IX is part of the Education Amendments of 1972, and this statute was enacted to address sex discrimination in educational institutions. So once again, that sex term comes up, and there has just been a lot of different interpretations about who is protected under Title IX. But for the most part, Title IX seems to usually follow Title VII in terms of interpretation. While this statute was enacted to address sex discrimination, mostly for students in educational institutions, we also find inequities exist for women who are working at educational institutions. And although there have been increasing opportunities for women employed in education compared to their male peers, women on average are still paid less, which we talked about with the Equal Pay Act. They hold a lower ranking title and are often not tenured. So Title IX protects people from discrimination on the basis of sex, also in the employment context, in education programs or activities that are receiving federal financial assistance. So if you were the plaintiff, you would need to prove those three elements of gender discrimination that's happening in a place receiving federal funding, at like an educational institution or program. Now, this discrimination may include, once again, this list of different employment practices. So it could be related to recruitment, hiring, tenure, firing, rates of pay, fringe benefits, leave for pregnancy or childbirth, participating in employer-sponsored activities. Any number of employment practices can be considered and protected under Title IX. As I mentioned previously, Title IX is enforced by the Office for Civil Rights. However, when an employment discrimination complaint is filed, it is usually referred to the EEOC, whereas the Office for Civil Rights will examine any of the claims that are based on like discrimination in education programs, such as student athletes or students who have differential access to education programs. That would go through the Office for Civil Rights. And the Title IX versus Title VII, I find so fascinating. So if you experienced employment discrimination, right, and you file a complaint with the EEOC, what federal law do you cite, right? Because there's some overlap here. We have, if it's a sex-based discrimination, we have the Equal Pay Act, we have Title VII, and we have Title IX. So which act should you cite? And different circuits within the United States actually have different opinions about this in terms of, well, this is the law that you should file. So in the state of Ohio, we are in the 6th Circuit, and the 6th Circuit has found that Title VII does not preempt Title IX. What that means is that you are permitted to pursue a complaint under Title VII and or Title IX, whereas there are other circuits that indicate that Title IX is preempted by Title VII. So the 5th and 7th Circuit basically indicate that a plaintiff, if filing an employment discrimination complaint on the basis of sex, must use the remedial administrative scheme Congress established in Title IX, which is a fancy way of saying you must go through Title VII. There are some reasons for why certain circuits feel that you should go either Title VII or allow you to go either Title VII or both, because there actually are some implications here. For a Title VII complaint, you are required to file that complaint with the EEOC in either 180 days to 300 days from when the alleged discriminatory action occurred. So you have roughly half of a year up to a year. However, Title IX actually does not have a statute of limitations, and the courts have generally followed a personal injury action, which is typically 2 to 3 years from when the alleged discrimination occurred. So Title VII, you have 180 to 300 days. Title IX, you have up to 3 years. That's a lot more time to file this lawsuit. Also, the money available as a remedy is different. Under Title VII, there is a cap for compensatory and punitive damages. Under Title IX, compensatory damages are not capped, but you don't have access to punitive damages. So there are a lot of different little nuanced differences between these two laws that could be advantageous to the plaintiff and adverse to the defendant. For example, if there is a Title IX complaint, it can have significant impacts on the educational institution and its programs in comparison to a Title VII complaint. But anyways, what you need to know is that in our circuit, you could pursue either Title VII or Title IX or both, whichever is to your benefit. So that is a quick review of all of the relevant federal laws that pertain to employment discrimination. I kind of wanted to pull this all together for us in terms of burden of proof. So this is the order of burden of proof if you were to file a complaint with the EEOC. If you are an applicant for a position, you need to prove that you are a member of a protected class, that you applied for a job for which the employer is seeking applicants, you are qualified to perform this job, you were not hired, and the employer continues to seek applicants after your rejection. But when you're proving that you are not hired, you have to prove you are not hired because you are a part of a protected class. So that's an important piece, and there was discrimination involved. If you are an employee, so once again, you do need to prove that you are a member of a protected class, you were performing your job satisfactorily, and you were discharged or adversely affected in your work conditions, and your work was assigned to someone else. So that is what you need to prove. You're a member of a protected class, and you need to demonstrate the discriminatory employment practice. And then the burden of proof will shift to the defense, who must prove that the alleged discriminatory employment practice was for a legitimate, non-discriminatory reason. So you need to have a clear justification for your employment practice, which, for example, in the US women's soccer complaint, we saw that the US Soccer Federation was able to demonstrate a justifiable defense through the collective bargaining agreement. If the defendant is able to provide a legitimate non-discriminatory reason, the burden of proof will once again shift back to the plaintiff. And it is at this time that you need to prove, or the plaintiff, that this legitimate reason is actually pretense for intentional discrimination. And you can do this in a few different ways. You can provide direct evidence of prejudice toward either the plaintiff yourself or other members of the protected class. So direct, hard proof evidence. Present statistical evidence to show, just from a statistics standpoint, how members of a protected class are being treated differently in terms of work conditions, compensation. So stats, always a great way to build up your evidence. Or present comparative evidence that members of a protected class are treated less favorably to members of another class. So honestly, just it's up to you to not only prove the discriminatory employment practice, but to back it up with evidence to show differential treatment in the employment context. And then once again, the burden of proof would shift back to the defendant, who would need to prove that the plaintiff's evidence basically lacks merit. So it's a bit of a back and forth game, but you're trying to prove discriminatory employment practice if you're the plaintiff with evidence of that discrimination, and the defense is trying to prove a legitimate justification for that employment practice. So if there is a complaint that is filed, there are several defenses that employers can think that they can use or take into consideration. So we're going to go through a few of those. The first one is a bona fide occupational qualification. So the BFOQ defense requires that the employer prove that members of the excluded class could not safely or effectively perform essential job duties. Now, the employer must have a factual basis for believing that persons in the excluded class could not perform the job. It must be something that is reasonably necessary to the normal operations of business. So this expectation, what is this like performance of job duties? It needs to be necessary to the normal operations of the business. An example of a bona fide occupational qualification would be pertaining to religion as a protected class. My parents, Dave and Pat Lauer, work for a Christian organization called Athletes in Action. It is a sports ministry whose primary purpose is to share this faith with others through sport. And so within their application process, they have a requirement that the applicants observe the Christian faith that the organization is based on. And it is considered a bona fide occupational qualification because in order to perform the job duties within that organization, which is to further this faith, it is reasonably necessary that the employees observe that faith. So that would be an example of a BFOQ. However, race and color are never, ever bona fide occupational qualifications. Just wanted to point that out. Business necessity is fairly similar to BFOQ. For a business necessity, the employer has to prove that a particular practice is job related. And therefore it's a business necessity, it just might have a discriminatory impact on a particular group of people. So with business necessities, I often think of gender discrimination and certain manual labor jobs that might require certain physical ability. It could potentially have an adverse effect on women who are anatomically different from men. However, if the physical skill or qualifications or strength is necessary to perform the job, then the employer could cite business necessity for that qualification. And then seniority system is also a defense that can be used, and we often see seniority system for the hiring and promotion process. And this essentially recognizes job tenure and will allocate opportunities based upon that. So the longer that you're in your work, the more likely that you have an opportunity for promotion or a job reallocation and just different employment opportunities because of your time spent there. So seniority system can also be a justification for providing certain employment benefits to groups of people over other groups of people. And then a few other defenses for us to consider is the merit system. So the merit system and system based on quality or quantity of production, I see those as kind of going hand in hand. And this is essentially when applicants are hired or employees are promoted based upon their performance, right? Based upon their quality and quantity of production is justification and merit for receiving employment opportunities and benefits. Another defense that we will see is affirmative action. An affirmative action involves creating policies that give preference to those who are underrepresented in the workplace. And it really changes based upon your industry. So pay attention to your industry in terms of, are those underrepresented, those who are minorities based on gender, minorities based upon their race or color or national origin. But these affirmative action initiatives are intended to increase the diversity of your workplace. And they are legal if the program is formal and systematic, it's temporary and operating until its goal of increasing the percentage of underrepresented workers is met in order to rectify past discrimination. The program is legal if it doesn't bar an employer from hiring or promoting a non-minority individual. It's legal if the program does not result in the firing of a non-minority worker. And it's legal if the program does not force the employer to hire or promote an unqualified worker. So essentially, this program is legal when if a minority applicant and a non-minority applicant with equivalent qualifications were to apply to a job, the employer chose the minority applicant based upon a formal affirmative action program to increase the underrepresentation of that minority group in their workforce. But it shouldn't have adverse effects on non-minorities, just so you know. And you need to still hire the most qualified person. And then another defense is reduction in workforce. So essentially, if an employee is let go because of a layoff in regards to cost-cutting measures and not because of their race specifically. And please note that that employee is not replaced. It is just a layoff to reduce the workforce, most of the time for budgetary reasons, can be a legitimate defense. And then lastly is our catch-all. Any factor other than their protected classification. If you can prove your employment practice was for any other reason other than their protected class, so their age, their gender, their race, ethnicity, things of that nature, that would be a viable defense. However, if your defense does not land, if the employer is found liable for employment discrimination, there are a number of different remedies that the courts can adopt. And on this slide, you'll see just a list of what is available to the plaintiff. The first one is called a non-discriminatory placement. So when the EEOC finds that an employee was discriminated against, they can require the employer to provide that individual with the position that they should have occupied if they weren't discriminated against, or the position that they sought, or a substantially equivalent position. And it may come with back pay potentially. So back pay, the purpose of back pay is to restore the injured party, so the plaintiff, the income that they would have earned if it weren't for the discrimination. And it may include lost wages or benefits that would have been earned were it not for the discrimination. So that reinstatement can come with back pay. The plaintiff could potentially receive front pay. So front pay is an equitable remedy that compensates an individual when reinstatement to a position is not possible based on certain circumstances. So if reinstatement is not possible because the position is not available, or because a subsequent working relationship between the employer and the employee would be antagonistic, so basically not to the benefit of anyone, or the employer has a record of long-term resistance to anti-discrimination efforts, basically like they are not going to create a position or allow you to pursue an alternative position, then the courts will provide front pay, which is pay for loss of future wages that you didn't have access to. There are other forms of equitable relief, such as potentially canceling an adverse employment action that impacts the status of the employee or the applicant. Also providing the applicant or employee the full opportunities to benefit from their employment that was denied. So this could be providing training, preferential work assignments, overtime scheduling, any benefits that they were denied. And then lastly, there is also compensatory damages that are available. So if a plaintiff is able to establish unlawful employment discrimination, in addition to the equitable remedies that were just described, so reinstatement, back pay, front pay, the plaintiff can potentially get compensatory damages as well for past or future losses. So past losses would be like pocket expenses, attorney fees, things like that. And then future losses might be pain and suffering or mental anguish from your experience of employment discrimination. So compensatory damages are also available to the plaintiff. And to conclude, I'd love to leave you with this thought process. On the screen, you will see a number of employment practices listed, and in our industry, we are continuing to see increased momentum and attention paid to addressing justice, equity, diversity, and inclusion. It's so important, and I encourage you to consider how you can promote justice, equity, diversity, and inclusion through these employment practices while you are in the industry as a sport manager. So how can we rectify past employment discrimination and increase opportunities for protected minority classifications and groups of people?